And welcome. As the lineup of our speakers is now complete, let me welcome you on behalf of the Sant'Anna Legal Studies seminars to this wonderful transnational, as Giuseppe said, transnational event. We have a speaker from Japan here, but we also have people from other corners of the world, Italy, but also Armenia. I see some person from Armenia joining us today. Welcome to this event, which features a very interesting talk, I should say, on a very important and a modern issue about the different forms of constitutional transnational adjudication that come together in Yota Negishi's new book, which was just published and which is accessible online, that everyone can read and enrich the horizons of legal thinking by actually doing that. So without further ado, I'm happy to introduce the main speaker, Yota Negishi, who is joining us from Fukuoka, Japan today, but also the two other speakers who will comment on his book. This is Antonia Baraggia from Milan and Sabrina Ragone from Bologna. Because we were a little bit late, without further ado, I want to pass the floor to Yota and welcome him to this event and ask him to present his wonderful book here.
May I share my slide?
Sure.
Okay, thank you.
Yeah.
Okay, thank you very much. Hello, my name is Yota Negishi, and Associate Professor of International Law at Seinan Gakuin University, Fukuoka, Japan. First of all, I really appreciate Giuseppe for preparing this precious event. Giuseppe, for me, is kind of a spiritual mentor, and he always gives precious advice to my research. And I also thank Armen, and nice to meet you, and for taking the chair today.
My pleasure.
Antonia and Sabrina, well, I'm really happy to meet you again online. Yeah, Antonia was the organizer of international conference in which I presented the very first English presentation. So I really remember that event. And Sabrina was the colleague at the Max Planck Institute. I'm really happy to meet you online. Thank you. And thank you very much for taking the efforts to as commentators. And I give my gratitude to every participant in this event. I'm highly honored to present introduction of my recent publication titled The Conventionally Controlled Domestic Law, Constitutionalized International Adjudication and Internationalized Constitutional Education. It's a little bit longer, but yeah, it has a message to combine international and domestic spheres. So here is the structure of my presentation and book. In this opportunity, I would like to illustrate the whole picture of this project rather than to examine specific cases. First, I will identify the research problem and the object of the project, the doctrine of conventional control. And then second, I would like to digest the contents of each part and each chapter. And third, I will present the most original contribution of this book, that is the Trumpet model instead of pyramidal model, regarding the relationship between international and domestic law. At the outset, let me explain the background of this research. Structural human rights violations caused by unconventionality of domestic law. So within the so-called Westphalian system, nation states with sovereignty have primary roles, primary powers and duties to implement international obligations. According to the structural principle of subsidiarity, international institutions such as human rights treaty bodies remain complementary or subsidiary to the primary role of states parties. What if, however, human rights violations occur not in single cases, but rather in a systemic way due to the incompatibility of domestic law with international obligations? That scenario often happens in the state party, where the executive bodies exert political pressure on legislature and judiciary. In that case, the unconventionality, incompatibility of domestic law with international standards has resulted in repetitive cases like clones in which vast number of victims make similar claims on the same factual basis. Then we can ask whether human rights treaty bodies should refrain from exerting their powers because of the meaning of subsidiarity, original meaning of subsidiarity, or should human rights bodies reconfigure the meaning of subsidiarity to proactively engage in the primary responsibility of state parties? This is a background question of the project. Then the main topic of this monograph, the doctrine of conventionality, comes in the scene. Indeed, the doctrine emerged to address such structural violations of human rights. The doctrine was firstly invented by the Inter-American Court in San Jose in the case concerning self-amnesty law in Chile. In this decision, Inter-American Court suggested, I quote, the judiciary must exercise a sort of conventionality control between the domestic legal provisions which are applied to the specific cases and the American Convention on Human Rights. The doctrine of conventionality control has, in my impression, at least two implications to rethink the most important, one of the most important fundamental legal questions, that is the relationship between international law and domestic law. The first implication is what I call constitutionalization of international law. Not only the Inter-American Court, but also the European Court of Human Rights started to behave as regional constitutional courts, and they make authoritative interpretations and conduct judicial review of national acts in light of their own jurisprudence. The doctrine of conventional control requires human rights courts to focus on the public, even constitutional aim of the regimes in Europe and Latin America beyond individual dispute settlements. The second implication is the part of blue in this slide, what I call internationalization of constitutional adjudication. Domestic courts have assumed the control of constitutionality as a traditional task, namely the compliance of legislation with national constitutions. In addition, domestic courts in the contemporary era also have another important role to review the legality of national acts in light of international obligations, mainly the regional human rights conventions. The doctrine of conventionality control therefore converts domestic judges as the primary and authentic guardians of legal orders established by both national constitutions and human rights treaties. The monograph elaborates on such dynamic process of top-down constitutionalization and bottom-up internationalization of adjudication in both regions, Europe and Latin America. In this book, I set a research framework to analyze such parallel phenomena at the international and domestic. For this purpose, to set the research framework, I refer to the Inter-American Court jurisprudence, which is very useful to formulate the framework. I quote, the organs of the judiciary should exercise not only a controllable constitutionality, but also conventionality ex officio between domestic norms and the American Convention, evidently in the context of their respective spheres of competence and the corresponding procedure regulations. This explanation is highly suggestive because it established a research framework as regards conventional control, namely parameters on the one hand and powers on the other hand. Indeed, as I put chart on this slide, as this indicates, the book establishes the framework of parameters and powers of conventionality control in relation to constitutionalization of international adjudication and internationalization of constitutional adjudication. So there are two parts and 4 chapters, because chapter 1 examines the parameters and chapter 2 examines the powers of organs. The first research framework concerns the relationship of norms that is parameters. The parameter as the yardstick by which conventional control of domestic law is achieved. Indeed, the Inter-American Code refers to the control of domestic law in terms of both constitutional and conventional parameters. Then chapter 1. In chapter 1, I examined the first aspect of constitutionalization of international adjudication. In that phenomenon, human rights courts authoritatively interpret the parameters of conventionality control, like the National Constitutional Court. First, I described the recent interpretive practices of evolutionary interpretation of regional human rights treaties as living instruments. In practice, both European and Inter-American courts tried to bridge regional conventions with human rights standards accumulated in the universal level. So there is a bridge between region and universal level. It is also proved that this practice that extends beyond state contents requires a shift in the source of legitimacy from regional consensus between state parties to the universal consensus accumulated at the global level. I try to normatively justify such practices. Then I invoked the pro homine principle that is reflected in more favorable clauses of human rights conventions, such as Article 29B of the American Convention on Human Rights. The pro homine principle, or the more favorable clauses, requires interpreters to interpret and apply the most favorable protection in favor of individuals, not of states. So as the horizontal functions regulating regional and universal standards, the pro homine principle have dual function. On the one hand, the pro homine principle contributes to constitutionalist unification between regional and universal standards. But on the other hand, it also allows the pluralist diversification of international human rights law. So there is a two different strands, the function of the pro homine principle. Then in part 2, chapter 1, I examined the application stage of conventionally controlled parameters. This chapter addresses the first aspect of internationalization of constitutional adjudication. In this phenomenon, domestic judges are required to exercise control of domestic law in accordance with national constitutions and regional conventions. The chapter first examines the battle for supremacy between regional conventions and national constitutions. On the one hand, national constitutions incorporate regional conventions and the regional courts' jurisprudence. So in this sense, the supremacy of national constitution is relativized. On the other hand, we can observe some cases of contestation based on constitutional principles or sovereignty against regional conventions and regional courts' jurisprudence. So there is a kind of conflict and battle for supremacy between national constitutions and human rights treaties. To alleviate the tension between such conflicts between international and conventional legal orders, I again unpacked the potential of the pro homine principle here. The pro homine principle have two functions in this regard. The first is the offensive function as a sword to penetrate the border between international and national legal order, because the pro homine principle always require the most favorable protection of protection for individuals. So if the international sources have more ample protection than national constitution, the pro homine principle always require the application of such a higher level at the international source. Then the pro homine principle acts as an offensive sword to penetrate the border between international and domestic law. On the other hand, the defensive function can be observed in terms of national constitution. If national constitutions provide more ample protection than international sources, the pro homine principle provides a shield for national constitutions against the penetration of international sources. So here, again, there are two different strands in the Prohibited Principle application. These chapters are related to the parameters, the relationship between norms. But then next two chapters, part 1, chapter 2, and part 2, chapter 2, relate to the distribution of powers. First, part 1, chapter 2, relates to international distribution of between human rights courts and domestic authorities. This chapter examines the second aspect of the constitutionalization of international adjudication. In this phenomenon, human rights courts perform judicial review of national acts against the yardstick of convention's parameters. As a structural principle of international human rights law, as I said, the subsidiarity requires that the state parties have primary responsibilities, and human rights treaty mechanisms are just subsidiary or complementary to the primary role of state parties. However, this otherwise means that subsidiarity can inversely reallocate the authority to the higher level if, and to that extent, the higher level is better placed to fulfill the task in question. Considering these negative and positive sides of subsidiarity, this chapter demonstrates that the principle of subsidiarity allocates judicial powers either to state parties or regional courts, depending on the achievement level of human rights protection. If the state parties perform the primary responsibilities, the higher level of human rights mechanisms should be subsidiary in the negative sense. However, if the state parties does not perform correctly in accordance with international standards, the human rights mechanisms should proactively dive into the domestic sphere to eradicate the root causes of structural violations of human rights. Then I advocate the hybrid model of conventionality control under the principle of subsidiarity. The first is the concentrated conventionality control by human rights courts behaving as a regional constitutional courts within the regime, in the region. This is justified by the positive side of subsidiarity. On the other hand, the second aspect of the model is the diffused or decentralized conventionality control by national authorities, especially domestic courts, under the original meaning of negative subsidiarity. And then the last chapter deals with the second aspect of internationalization of constitutional adjudication. This chapter relates to the relationship between constitutional and ordinary judges within the domestic sphere under the influence of human rights treaties. In this phenomenon, the distribution of powers between constitutional and ordinary courts is allocated in accordance with regional conventions as well as constitutional mandates. According to the inter-American jurisprudence, the judiciary at all levels must exercise a sort of conventional control between the domestic legal provisions and the American Convention, evidently within the framework of their respective competence and the corresponding procedural rules. This position embraces both permissible and restrictive aspects concerning the distribution of powers. As for the first aspect, restrictive aspect, conventionality control must be performed by all judges, regardless of their formal membership in the judiciary branch and regardless of their rank, grade, area of expertise, and level. However, the other side, the permissive aspect, states parties are granted certain discretions about the model or ways of achieving conventional control. It means that they may exclusively entrust constitutional court to perform conventional control in line with the concentrated powers of constitutionality control. under the domestic law. So we have overviewed the content of the 4 chapters, and let me summarize the analysis in each chapter so you can see the results of the each chapter. The first chapter is interpretation of conventional control parameters by human rights courts, and it is applied by domestic judges. And the chapter 2 is the allocation of powers between regional courts and domestic authorities. And the last chapter relates to the distribution of powers within domestic sphere between constitutional and ordinary judges. There are four chapters. And chapter 1 of each part, this line, reveal that the interpretation and application of conventionality control parameters combine unifying and diversifying approaches depending on the protection level of universal, regional, and constitutional norms in light of the Prohibited Principle embedded in the most favorable clause. In addition, the chapter 2 of each part demonstrated that the allocation of conventional control powers can also be centralized or decentralized, depending on the nature of labor among regional, constitutional, and ordinary courts. So this is the empirical data. And based on that data, I finally established a normative model of conventionality control. The most original contribution of this book is to propose a new account on the relationship between domestic law and international law. Then I would like to overcome the limits of so-called monism, monist pyramid. In the pyramidal model, this is very famous, advocated by Hans Kelsen. The summit fixes either international law or national constitutions as a supreme norm over the other. However, as the present monograph has proved, the contemporary state of affairs poses huge challenges to the supremacy of international law and constitutional law, respectively. So in the era of internationalization, the pyramidal model is criticized harshly because of its closed-mindedness, formalist, and state-centric characters. So then instead of the monist pyramid, I propose the Trumpet model in light of constitutional pluralism. In this model, the upper base consists of both legal sources, constitutional law, and regional international law. I identify the following 3 features of the Trumpet model of conventional control. First, equating international standards with constitutional standards opens up the closed-mindedness of national constitutions to the international society. So the openness is the first feature. And the second, instead of the formal rank of source, formal supremacy of international law or national constitution, the substantive values recognized in both sources, regional and national, should be prioritized. And such common values, common features in both sources should be put on the top of the trapezium. Third, above all, the substantive values shaped by an open interaction between sources, different sources in international law and domestic law, are construed, interpreted for the sake of persons, not for the states. So this is the attempt to overcome the state-centric idea in the constitutional education. So these 3 features are the very important core values of the Trumpet model I proposed in the last conclusion in this book. So with these short statements, I conclude the introduction of this book. So my explanation is rather vague and very kind of sketching the whole picture of this project. So if you have some questions to concretize the problem, so please ask me. So which point are you interested in? And I thank you to commentators, Antonia and Sabrina. And any points are welcome. Any questions are welcome. Thank you very much. And this is access to the material, open access as introduced by Armen. And also thanks to Giuseppe, I also introduced a very short video in the DDT Comparati. Okay, this is a summary and of my presentation. Thank you very much.
Thank you very much, Yota, for a very comprehensive, interesting presentation, but not least also for being exactly fitting it into the respective timing so that we have more time for the commentators and for questions later, as you assumed also. So now we can go to our commentators, excellent commentators, and perhaps we can start with Antonia. Please, I would suggest that you take some 15 minutes.
Okay, thank you very much. Can you hear me properly? Okay, great. So thank you for this invitation. I really enjoy reading the books by Yota Negishi, which address a very topical theme in constitutional and international adjudication. I would like to focus on some aspects of Yota's book. In particular, I would like to highlight this tension between the international standards and national claims, which is a tension that we see in these dynamics between regional courts and constitutional courts. And it is a dynamic that we see very clearly within the European Union system today, with this clash between national sovereignty claim and the European standards with the rule of law, for example. So the red line of my comments will follow this tension. So the first point I would like to comment upon is the role of the dynamic interpretation given by these regional courts. And you currently points out the key role of the European Court of Human Rights in this dynamic interpretation in human rights protection. And you quoted an important case of the European Court of Human Rights, which is ABC versus Ireland, which was a landmark case dealing with the abortion regulation in Ireland. And I would like to stress the fact that you are perfectly right that in this case, the court adopted an evolutionary interpretation based on consensus among state parties. But in the ABC versus Ireland case, we see exactly this tension. So on one side, the court acknowledged that there is a wide consensus towards a kind of liberalization of abortion rights, but in the end, it plays the card of margin of appreciation. So I think that ABC versus Ireland case is a clear example of this ongoing tension, and also the fact that the European Court of Human Rights was very paid a lot of attention in not stressing too much the evolutionary interpretation in a sensitive field like abortion regulation. In the end, the European Court of Human Rights was able to influence the domestic evolution, as we all know, in the abortion regulation in Ireland, but not forcing the system towards a given direction. And we can see this also in the case law over same-sex partnership in the European Court of Human Rights. So the European Court played a pivotal role in cases like Ogliari versus Ireland versus Italy, Orlandi versus Italy, but and it stressed the concept of the common interpretation of the principle of equality, of private life, and so on and so forth. But in these cases, we can see a kind of tension with the principle of parliamentary sovereignty. So the Italian legislator took a specific route, which was contested, challenged by the European Court of Human Rights. So my question with regard to these sensitive cases is, of course, the regional court pushes for the evolutionary interpretation based on the principle of consent, but is this practice in contrast with the principle of parliamentary sovereignty? It is a kind of challenge to the separation of power in the domestic system. So I think that reasoning about this sensitive case, so same-sex partnership, abortion, end-of-life decision, highlights these light and shadows of the evolutionary interpretation of regional courts. The other point that I would like to stress is about the role of regional courts in socio-economic rights adjudication, because in a part of your book, you clearly state that a similar trend occurs in the development of socio-economic and cultural rights. You mainly focus on the Inter-American Court, using the evolutionary interpretation to address, to protect, for example, property rights of indigenous community. But my question is, so we can claim such a strong influence of regional court also on the field of socio-economic rights? It seems to me that looking at the European Court of Human Rights, I would be more cautious in claiming this, because, of course, ruling on Protocol 1, so on property rights, the European Court of Human Rights was able to address some issue dealing with socioeconomic rights, but I think that still socioeconomic rights adjudication is very weak. It suffers from the lack of jurisdiction of the European Court of Human Rights. So I'm not so sure that the evolutionary interpretation plays such a role, at least at the European in the European context. Another interesting part of your book addresses the use of other international treaties different than the regional convention to address human rights issue and to to develop this evolutionary protection interpretation of human rights. And here my question is, don't you see a risk of a kind of cherry picking of international treaties to advance a particular idea, a particular form of protection? So because I've seen several cases in which the court mentioned some treaties, but they do not refer to other relevant treaties in the field of human rights protection. So my question is, so how the regional court refer to the other international instrument? And don't you see, as I said, the risk of choosing in a sort of cherry picking only certain international treaties? Another point is about the risk of fragmentation linked to the application of the principle of subsidiarity. So I completely share your point about the risk of fragmentation, and this is clear if we look at the religious rights adjudication. So the jurisprudence of the European Court of Human Rights dealing with France and Italy is clearly an example of this kind of fragmentation. But again, is not this outcome, which seems not fully coherent if we look at the European Court of Human Rights jurisprudence, an example of this attention paid to the specific national context of every domestic system. So we all know that the concept of laïcité in France is not the concept of laicità in Italy. And so I think that, yes, there is a fragmentation, but it is, in my view, a kind of it can be justified because the European Court of Human Rights, being an international court, needs to look carefully to the specific domestic context. And so the case, the Lauzi case, I think it's in comparison with the SAS judgment versus France, is a clear example of this deference by the European Court of Human Rights to the domestic system. And here is where subsidiarity comes into play. I really like your distinction between positive and negative subsidiarity. I think it's really enlightening the jurisprudence also of the European Court of Human Rights. They use the twofold use of the subsidiarity principle. And also, I would like to elaborate a little bit on the concept of the margin of appreciation doctrine, because you clearly state that the margin of appreciation doctrine has been developed as a corollary of the subsidiarity principle. So margin of appreciation refers to a degree of flexibility in the operation of the law and calls for a certain deference towards the principal actor of society. I think that this doctrine is really key one for managing the tension that I mentioned above, especially in a context in which, as you also claim in your book, we are witnessing to challenges coming from regimes, states that contest the international standard of human rights protection. So I think that, and the fact that the Inter-American Court doesn't rely on so much on the margin of appreciation principle, it is an interesting aspect to reason about the different role of the European Court of Human Rights and the Inter-American Court vis-a-vis the specific context, the specific domestic context in which this court play a role. Another point that is very interesting is about the approach that the national constitution takes vis-a-vis the international law, international treaties. And you mentioned that in some countries, national constitution incorporates an express provision that requires consistent interpretation. And you mentioned, for example, the case of Austria, in which the European Convention has been granted constitutional rank, and so it has been fully incorporated into the constitutional adjudication. And you also mentioned the case of Switzerland as a case in which has been given to international law a priority over national law, where they conflict one each other. And on this aspect, I would like to raise a point about the fact that in Switzerland, of course, there is this kind of relationship between international law and constitutional law, but especially in recent time, we have seen, again, a tension between international law and domestic law, between human rights standard, universal human rights standard, and deliberative democracy. For example, the referendum on the minarets case, so the fact that through referendum approved by the people of Switzerland, it has been introduced in the Constitution of Switzerland a provision that forbids to build minarets on the Swiss territory. This is clearly against the freedom of religion, the also Article 8 of the European Convention of Human Rights, but these conflicts cannot be brought in front of the Swiss court, because the only limits to popular initiative is the use cogens. So there is not a limit that can come from the treaties, from the international treaties. So there was no way to claim the unconstitutionality of this provision, which clearly goes against the protection of freedom of religious freedom. So again, this tension between democracy on one side and human rights standard on the other. And here comes my last point about so the rising challenges towards international law. So we see in Europe especially, but as you correctly state, not only in Europe, all over the world, a rising contestation vis-a-vis international law. And on this point, I would like to stress one of the most recent developments of the European Union law. So you claim correctly, in my view, that the notion of constitutional identity has been abused in order to challenge the rise of this international human rights standard. We see this clearly looking at the European Union law, in particular with regard to the Hungarian Constitutional Court, but also most recently with regard to Poland. But in the one of the last important decisions of the European Court of Justice, the decision of 16 February 2022, for the first time ever, the European Court of Justice uses the concept of European identity, which cannot be challenged by the national identities of the member states. So in this decision, the European Court of Justice for the first time framed this concept of European identity, taking, of course, into consideration and protecting the claim that there are national identities, because even the treaties protect these national identities in Article 4.2, but it claimed that there is a European identity, and once a state become a member of the European Union, cannot claim to have an identity, in contrast with this concept of European identity. So I think that things are evolving even in the international and supranational sphere, if you want to call it, the European Union law, in order to address this tension and to counter-react these rebellions against international law. I stop here. I had other small points, but I stop here, and maybe we can go back in the Q&A session. Thank you.
Thank you, Antonia, very much. Now let's connect to Bologna and Dr. Sabrina Ragone. Please, your time, and I would appreciate if you suffice with comments within 15 minutes.
Sorry, Armen, just to pronounce the surname correctly, Ragone.
Ah, I'm sorry.
Ragone. No problem at all. I mean, I wanted to abuse my position. Sorry. Bye-bye.
But it's okay, you know that ragione means reason, so if I'm always on the right side, it's still okay. So you can call me in any way you like. So I'm very happy to be here and share this panel with very good friends, so former colleagues, but even more friends. I will start with a few things that I liked in the book, and then I will focus on some aspects that I would like to discuss with Yota. And I have taken many notes while I was going through the book, but of course I promise that I will focus just on a few things. So I like the structure of the book. I think it's very well organized. I like the style because it's easy to read. You can always grasp the meaning of what Yota means. It's clear that he has been going through the book for, many times until reaching a clear way of explaining everything. Of course, I love the charters and the geometrics of the book. And last but not least, open access is an asset. So very good choice. It's a strategic choice, and I think it's going to make this book an incredible success. Now, let me start with the title. So in the title, as you mentioned in your presentation, Yota, you refer to both international law and constitutional law, because you talk about constitutionalized international adjudication and internationalized constitutional adjudication. And I think that this the title recalls previous studies concerning how international law has entered more and more into constitutional law through human rights treaties, and how, let's say, the opposite phenomenon has happened over the past decades. And also in the book, you deal with the concepts that you bring from international law and also from constitutional law or domestic law. And I would say that from the perspective of a comparative constitutional lawyer, as I am, the attitude that I would find in the book is more consistent with the attitude and the approach of an international lawyer, which is what you mainly are. And I would like to know if you perceive it this way and what struggles you had when addressing these issues from the domestic perspective. So trying to become a constitutional lawyer. I also think that the book is somehow a comparative law book. And in this respect, I have a couple of comments I would like to make. So comparing the inter-American system and the European system always give me mixed feelings, okay? Because of course these are the two, the most comparable international systems of protection of human rights, and I agree on this. But still, I think we should always ask ourselves to what extent they're actually comparable. And Antonia raised this point when she mentioned the margin of appreciation, which is something that is much more consistent with the attitude of the European court than the inter-American court. And I mentioned this comparability issue with respect to, for example, the context. Especially, I would say, if you think about the first decades of adjudication by the Inter-American Court, the cases that the court had to decide upon, the kind of rights and violations that the court had to decide about, are also some of the factors that, in my opinion, led to the impossibility of having margin of appreciation. I don't know. I think that somehow we are going towards more comparability and homogeneity between the two cases now, but still I would be careful, or at least I would, I would have required, I would have expected a little longer explanation. And also with respect to the conventionality control itself. So if you think about conventionality control and what you require from judges in the inter-American system and in the European system, if you, let's say, want to apply this doctrine to the European context, think about the poor, lonely, monocratic judge. So it's easier for a judge from a Latin American country, first because of language, but also because of the reduced number of judgments by the court, to be obliged and to feel obliged to know these cases. How can you expect that the lonely judge in, like province of wherever in Italy or in Poland or in any other country can be actually aware of all the judgments? We are talking about hundreds of judgments, even on just one topic. And that's something that makes the conventionality control a different issue, I think, in the two systems. Now, something, of course, Yota, you pick and choose, you do cherry picking with the comments and you choose whatever you want to comment on. So afterwards, I will just mention some things within the time frame that have been allotted. So about the relationship between domestic law and international law, which very clearly Antonia addressed the issue of the tensions between domestic law and international law, and I agree with most of the things that she said. I also had a point on the mechanisms that you mentioned in the book on how to incorporate regional conventions through national constitutional law or through national case law. I agree that consistent interpretation clauses help because they give an instrument to courts to rely upon and to refer to when they actually perform this function. And again, as you mentioned, like I think that you mentioned the Belgian case, but there are also other cases in which there are decisions by the constitutional courts or the highest courts incorporating these standards. And I was wondering whether you had any empirical evidence, maybe from political scientists or sociologists, that prove that one of these mechanisms actually works better than the other, and what is the theoretical qualitative difference between these two? Because you include them in the same subcategory, but one thing is to have a clause decided by the original founding fathers, and it's different when it is a court elaborating that, because it's a doctrine that can be changed, and it's also a doctrine that can be challenged by the other actors involved in the conventionality control. Just a few more things. So I think that in general, the book is written with a very clear fair play. So I will raise a few controversial issues to see whether you can, I mean, we can try to unveil some of your normative stance and your opinions, maybe more critical about some of the aspects. One point is a meta point, I would say, because at the end of the day, the conventionality control in the inter-American system has been elaborated by a court. It is part of the jurisprudence, and of course, it relies upon Article 2 of the Convention. But if you think about it, even the opposite way of understanding this issue would have been fair. So if the court had said, everything that I decide concerning one state applies to that state, and then I have to decide on different cases because I have to take into account the context, the legal system, the actual case related to other states. What I decide for one state is just for that one, and then I will have to receive other cases for other states. We know that there is, let's say, there are advantages to this doctrine, but we also should be aware that it's not the only one. And so I would like to know what you think about the fact that it's the court itself obliging judges and all the authorities within the member states to comply with standards that were created for other states. Let me say something more about the margin of appreciation. So you, at some point, you also said this in your presentation, and you basically claim sometimes that these international courts are comparable to domestic constitutional courts in the protection of human rights, as if they were regional constitutional courts. So I disagree with this idea. So I think that there are some essential features to international courts that really make them different from domestic constitutional courts. And one of these ones is the need for judicial diplomacy, if you let me use this term. So the degree of judicial diplomacy that you must require to an international court that has to rely upon the states belonging to the system is not the same as the kind of let's say grip that a constitutional court can have vis-a-vis the other institutions of the same state. And I would see the margin of appreciation doctrine within this framework. Also, the backlashes that you mentioned in the book, so the fact that there are, as also Antonia mentioned, states, governments that are challenging the authority of international courts and of international law in general. So shall these backlashes change the attitude of international human rights courts? I know that instinctively we are lawyers, so we would say no. But I work at the political science department, and I do think that the answer should be yes, at least partially. Of course, we cannot accept, like massive and gross violations. But if a court has actually to decide between keeping a state within the system, giving the state a little margin of maneuver, but keeping the state under the jurisdiction, and piecing the state so much that the state will leave the system, I'm not so sure that the best decision for the system itself and for the protection of human rights itself is to be super strict and at the end of the day pushing the state to leave. Two things on the conclusions, just 2 minutes. So you advocate for a shift from formalism to substantive protection, which is what the pro homine principle does and what those clauses requiring the higher standard of protection do. Now, I have here a theoretical issue, which is that again, in theory, this looks very clear cut. So you choose the solution that gives the higher level of protection, but still, the majority of the cases on which international courts decide, in this case similarly to constitutional courts, are not related to just one right. So you cannot decide that just one right is more protected than what is provided by a different regime, because we are talking about cases in which you have to balance rights. And so what are the challenges of these clauses when of the cases you have to decide what is the more let's say the preferable balance between two different rights. And I will conclude on a similar issue than the one that has been raised by Antonia, because if we look at your very nice reconstruction of the mechanisms, what we see at the highest point there is common values. And so my question is, what happens when these common values are not common anymore? And this is, for now, my last point. Thank you again.
Thank you a lot, Sabrina. I think we can open the floor for the rest of our audience to see if there are any questions around, and then give Yota the chance to reflect on this and the other potential questions. So anyone has a question to Yota in addition to the speakers?
Oh, yeah.
Yes, they have a question.
First our guest, and then I will say something. So first our guest.
Yes.
May I
Please.
speak?
Yes, please go ahead.
Thank you very much for permitting me in this seminar. My name is Hinako Takata, Associate Professor of International Law at Osaka University, Japan. Thank you very much for this great opportunity. Thank you very much, Negi-san, for your concise introduction to the book, and thank you very much for the insightful comments. I have 3 related questions related to the concept of common values. First of all, as being a Japanese, I had the privilege to read both the PhD thesis on which this book was based and the book. So I sort of read both of the versions, comparing these 2 versions. And one thing that I noticed is that in your PhD thesis, you use the word 普遍的な価値, universal values, instead of common values when you introduced the one on top of your tropism. So I was wondering if there was any reason for this change of terminology. That was my first question on common values. And the second question is about the content, concrete content of the common values. I did understand that common values within your meaning contain human rights, but then do they contain other things such as the value of democracy, for example, or respect for cultural values? And in that, in such cases, I was wondering if such other values like democracy or respect for cultural diversity may conflict with the value of human rights, and what would happen in such a case. And the third question on, again, common values is that methods to identify the concrete content deriving from those common values. I do understand that it is easy and it is not controversial to agree that human rights should be included into those common values. But then I think when it comes to the discussion on concrete consequences deriving from those common values, it becomes very, very controversial. And in that respect, I was wondering if the concept of regional consensus approach has any role to play in identifying the concrete contents of those common values. For example, let's say, can the European Court of Human Rights say that, let's say, 40 countries out of 46 member states agree upon this concept or upon this measure, and therefore this should be included into the common values. So thank you very much.
Thank you, Professor Takata. Is there anyone else who wants to pose a question? Yes, Giuseppe, please.
Oh, just a brief comment and the question. I think that this work is really important for a number of reasons, and our discussants have already pointed out the most important elements present in this comparative analysis. I think it's a work of comparative supranational law, if we may use them in this label. And indeed, my question for Yota is, what were the main challenges for a work like that, from a methodological and from a substantive point of view? I remember the first time we met with Yota, I think it was in Belgium, in Antwerp. At that time, it was writing his PhD thesis, and I remember that he explained, I mean, the scope and the plan, I mean, behind the thesis, and I thought that this was a very ambitious plan, but actually, I think he really managed, I mean, to deliver a very sophisticated and then developed, I mean, analysis. So I want to just say congratulations. Since this book, I mean, could become, I would say, a sort of mandatory, let's say, bibliographical reference that for those who want to develop, indeed, I mean, the comparative supranational law. I was indeed curious about the methodological and substantive challenges that he encountered during his PhD thesis. Thank you very much.
Do we have other questions and comments in the audience? And if not, I see there are no others for the moment. Probably we can ask Yota to reflect on this very insightful questions so far, questions and comments. And we can see at the end if there are any additional ones.
Okay, thank you very much for insightful comments. And I got many issues which are very important and which also point out the limits of my research. And so I cannot answer all of your questions, but I will pick up some question and merge and bridge some of your related comments. And so I'm sorry, I cannot manage the whole picture, but yes, Antonia, thank you very much for your very critical and also valuable comments. Yes, I especially you started your comments with interpret the practices of human rights courts and the living instruments of the character of human rights treaties. Especially you mentioned the very politically sensitive cases of abortion and same-sex partnership in the European context. And yes, I dealt with dynamic interpretation in the part 1 and chapter 1. And this is a first aspect of constitutionalization of international law. And yeah, in human rights, I said human rights courts behave as kind of a regional constitutional court. This point was raised by Sabrina later. Yes, actually, so I started with the study of doctrine of conventional control in Latin American context. So that's why I rather focus on the constitutional role of human rights court as a regional constitutional court. doctrine of conventional control, the Inter-American Court explicitly said that the interpretation by the San Jose Court should be implemented by domestic courts. It is really a kind of monistic idea within the regional system. That's why my analysis is kind of biased to kind of interventionist attitude of human rights. But as you said, in the European Court is rather cautious to develop its case law. Traditionally, the European Court bases its legitimacy of interpretation in the regional consensus, and through the concept of consensus, the European Court pays difference or pays attention to the sovereignty system of the state parties, like parliamentary sovereignty, as you said. So yes, there is a difference between the inter-American and the European practices with regard to the dynamic or evolutionary interpretation. And in my analysis, the Inter-American Court is rather radical to develop evolutionary interpretation, even when it is not based on regional consensus. But the European Court is in principle very cautious to develop or adopt a new interpretation in a dynamic way. But in some cases, like same-sex issues, the European Court goes beyond the regional consensus and refer to the universal instruments, not only European but also universal instruments. And the European Court sometimes mentioned common ground or a kind of universal consensus and universal instruments. So yeah, it depends on the cases, and but in principle, the European Court is very conservative to and make difference to the national authorities and the national sovereignty, as you said. Yeah, I agree with this point. And you also mentioned about the socio-economic rights, and it's very interesting. I have not paid much attention to the second generation rights in my book, because the conventional control is more suitable to the first generation civil and political rights rather to the second generations. Because as you said, and Sabrina also mentioned about that, socio-economic rights is rather protected by the political section, like distribution of sources and logistical distribution should be determined by the political sectors. So the judicial organs is not so much equipped with such expertise. But it is interesting that Inter-American Court is also very active to expand the rights of socio-economic rights under Article 26 of the American Convention. So in this sense, the Inter-American Court is expanding and deepening the doctrine of conventional control to include the second generation rights. But as you mentioned, such kind of attitude of the Inter-American Court, I'm not sure whether this attitude of Inter-American Court is accepted by state parties, especially the jurisprudence on Article 26 of the American Convention. This is my next research task to examine whether the doctrine of conventional controls can be applied to second generation rights. Thank you very much on this point. And yeah, and on their interpretation, yes, you mentioned about the risk of cherry picking and fragmentation. I also addressed these points in some respects in my part 1, chapter 1, but I have not paid much attention to the cherry picking problem. As you said, the European Court or the Inter-American Court is rather active to refer to the universal sources to expand the scope of the regional convention. And the Inter-American Court also refers to the concept of a corpus juris of international human rights law, which is very original in the jurisprudence of Inter-American Court, with the concept of corpus juris. The Inter-American Court invoke every kind of international instruments, whether hard or not, to identify the so-called universal standards of international human rights. For example, the rights of the child, rights of the indigenous people, and rights of international humanitarian norms. But this practice of the corpus juris is also very dangerous, as you said, to choose the specific standards which are favorable to the conclusion of the Inter-American Court. So there is always a cherry-picking problem. In this sense, the European Court is rather cautious to refer to the external sources. This is also another case of comparison between the Latin American and the European context. Yes, but and fragmentation issue, like you mentioned about the cases before the European Court, like Bulkaban and Laishite cases. And another fragmentation is between the European Court and the Human Rights Committee, which interprets the International Covenant on the Civil and Political Rights. So yeah, so I also mentioned the problem of fragmentation. Yeah, this is also a very problematic phenomenon, and not only in Europe, but also between two regions and the regional versus universal system. In this sense, the interpretive techniques could be used to integrate the human rights standards, like the consistent interpretation Sabrina mentioned. This kind of a technique or mechanism can be introduced to integrate the human rights standards. But yeah, as I examined in the jurisprudence of Inter-American human rights European courts, yeah, different organs, different international courts and bodies can interpret the same rights in a different way. So yeah, we can see the phenomenon as kind of a risk, as a fragmentation, but rather such kind of a different point of view could produce a fruitful dialogue between different jurisdictions. So yeah, fragmentation can be labeled as risk, but in my thesis, I refer to fragmentation rather as kind of a healthy diversification, which can be produced by different organs. So different voices regarding human rights protection can produce the dialogue between judges and the bodies. So that might result in a fruitful protection level of human rights. Yes, and you also mentioned in the last part the rising challenge in the European Union law and community law and the European Court of Justice jurisprudence on the constitutional identity. I have not studied a lot about European identity, so it is very interesting to hear that concept. And yeah, I cited some cases of national identity by the national authorities, national state parties of the European Union. Yeah, the same kind of contestation is happening in the European and Latin American Convention of Human Rights. So for example, Venezuela and Dominican Republic, and yeah, Argentina or Chile or other cases. There are some contestation cases against the Inter-American Court, and of course there are many cases before the European Court. And the most radical one is Russia, and it will be not party next this year September. But the Russian Constitutional Court attitude is very kind of radical, and I cannot deal with such kind of a very not exceptional, but how to say, very hard to deal with. So, but there are some cases in which the contestation could produce a very healthy dialogue between judges. And my colleague Fulvio Palombino calls like consubstantial or a kind of a healthy disobedience against supranational bodies, and such kind of a disobedience against international judgments based on constitutional principles can produce a very interesting dialogue between judges. So not so in my research framework, is very difficult to deal with such kind of very rising challenges, rising contestation against supranational courts. But such kind of a very rare cases, we often focus on such very rare cases and very difficult cases. But in almost cases, the dialogue result in a very healthy way, and different such kind of a dialogue is kind of between the international and domestic courts. And yeah, thank you very much for Sabrina. You made a very fundamental question from the title to the last conclusion. And yeah, so my background is kind of public international law. So I started to study the jurisprudence of human rights courts. That's why my thesis is rather for international lawyers rather than constitutional lawyers. I imitate myself. I behaved like constitutional lawyers as possible, but my limits in my research was to find or to dive into the constitutional system of each state parties. Of course, I overviewed the core principles and core systems of each state party, but I had very difficulties to fully understand the mechanisms and problems and backgrounds of each state party. And for example, I refer to many Italian practices, and Italian constitutional courts and ordinary courts also very interesting to elaborate my research. But I sometimes had difficulties to understand the backgrounds and the implication of the judgments of the Corte Constituzionale. But in general, so I found a very general trend, general overview of the state parties with regard to the human rights jurisprudence in Europe and Latin America, and I could compare such kind of a general trend, and I find that the control conventionality, although it is embedded by the Inter-American Court, I think that doctrine can be, in theory, applied to the European Court of Human Rights. And one of the ex-judges, Garicci, mentioned that the European Court exercised kind of a controllable conventionality. But as you mentioned, that European very difficult to. There are many obstacles to make a complete comparison between Europe and Latin America, and this was also mentioned by Antonia. with regard to the margin of appreciation. And Sabrina kindly explained the history of Inter-American Court, why it have not invoked the margin of appreciation. So if giving margin to the state parties in which serious violations of human rights were occurred, state parties would have abused such kind of margin. So still there are many discrepancies between Europe and Latin America. And your question is very right. Is it actually comparable? So but I could find some similarities, especially in Latin America and Eastern Central Europe countries, in which the systemic violations were systemic violations occurred because of the incompatibility of domestic law with regional human rights courts. And in these regions, the Inter-American Court and the European Court are very active to dive into the domestic legal sphere to eradicate the root cause of the structural violations.
Dear Yota, I'm sorry, I have to tell you that if you can sum up in 2 minutes, that would be wonderful.
Okay. Okay.
Time constraints.
So, I'm sorry to take a long time. And you mentioned Hinako. Thank you very much for your question. And other Sabrina also mentioned the meaning of common values. This point should be sophisticated in more detail in my next research. But in most general cases, we can find common values. For example, we can see the common provisions in the constitutional rights list and the international human rights treaties. And there are the international human rights jurisprudence and the constitutional jurisprudence share most of the rights contents. But there are some very difficult conflicts between constitutional and international law. And so my thesis examined how to deal with such a very difficult conflicts. And in my model, I opened the possibility of decentralization and centralization and diversification and convergence. So it depends on the level of human rights protection, and it depends on the specific context of human rights in issue. Okay, thank you very much.
Fantastic, thank you very much. Apparently, due to time constraints, we cannot accept any more interventions, but we stay connected online and through all other means, and we're a community of lawyers who are interested in common subjects. And I want to thank the speaker and the other speakers, Yota, Antonia, and Sabrina, for your interventions. Yota, congratulations on the excellent book. Let's discuss it further, and let's again indeed stay connected and discuss issues of common interest in any other forums. And I'm hoping we can see you also in other events very soon.